Okay, right at the stroke of 7. Good evening, everyone. My name is Dr. Ray Adair. I'm the Executive Director of the Institute for Religious Liberty. It really is a great pleasure to have you here tonight. We've put together, I think, an exciting program that we hope you will enjoy as much as I've enjoyed chatting with these three speakers and getting ready for tonight. I'd like to begin by inviting our college chaplain, Father Gerald Waddell, to come forward and begin with a prayer.
Usually I make up a prayer of my own. I thought for this evening, instead, I would use the prayer that Thomas More includes at the end of Utopia, as Hypnodias is completing his description of that land. I think it will give us something to think about, and I hope not shock too many. O God, I acknowledge Thee to be my Creator, my Governor, and the source of all good things. I thank Thee for all Thy blessings, but especially for letting me live in the happiest possible society and practice what I hope is the truest religion. If I am wrong, and if some other religion or social system would be better and more acceptable to Thee, I pray Thee in Thy goodness to let me know it. For I am ready to follow wherever Thou shalt lead me. But if our system is indeed the best, and my religion the truest, then keep me faithful to both of them, and bring the rest of humanity to adopt the same way of life and the same religious faith, unless the present variety of creeds is part of Thy inscrutable purpose. Grant me an easy death when Thou takest me to Thyself. I do not presume to suggest whether it should be late or soon, but if it is Thy will, I would much rather come to Thee by a most painful death than be kept too long away from Thee by the most pleasant of earthly lives.
I'd now like to introduce our president, David A. Armstrong. He's in his 5th year at Thomasmore College, and is really the founder, along with a few of the other gentlemen who are here tonight, members of our executive committee that I will let him introduce, of our IRL. And as a lawyer himself, this is a very special topic for him. So, David Armstrong.
Thank you, Dr. Adair. It certainly is a pleasure to be here today to welcome you to our IRL event on legal perspectives. This is a very important dialogue that will take place tonight. Some people have their favorite constitutional right. I would say that the freedom of religion is the most fundamental of those constitutional rights. And it's important to have dialogue from many people on this subject. And you will see that. That's part of the genesis of the Institute for Religious Liberty. William T. Robinson III, class of 1967, Bill Madonna Thomas More, was the person that approached me on doing something as a citizenry to protect religious freedom. And he brought people with him, some of our executive committee, and I will have them stand up here to be recognized. Brett Greenhall and Dr. Gary Zola, please give them a round of applause. And also Aaron Bloodworth, who could not make it tonight. We had a meeting in, I think, 2014, and talked about the need for an entity that will educate citizens on this most fundamental right. Why? At the time, the Little Sisters of the Poor and the Hobby Lobby case were being argued with the Health and Human Services directive that everyone had to buy pregnancy protection in insurance, and we were asking the Little Sisters of the Poor to support that, and obviously that was against their religion and canon law, and so the case was very, let's just say, at the forefront of the news. And so when we talked about this Institute for Religious Liberty, we talked about major events, and we talked about the first event should be about the Little Sisters of the Poor case and the Hobby Lobby case, but we thought, you know what? We want to bring people together, and we thought that maybe that case was too hot to touch at that time. And so tonight is very special, because tonight, again, the genesis for this institute, we are going to be talking about that subject matter tonight. And it's events like these where we can have quality dialogue that are very important to the society of the United States of America. And I want to thank all of you for being here at this event, and for your support and advocacy of the Institute for Religious Liberty. And I want you to look around and see the diversity of our attendees. We have students, faculty, staff, community members, different faiths, different political parties. That's the most important thing. That's what makes this country great. That's why we are here. So I want to thank our speakers. We also have some former speakers from our previous events that are here. I want to thank our faculty at Thomas More College, our trustees, our administration, but especially our students for being here and taking part in this dialogue. And I see a couple smiles. I know some of you were made to be here. But at the end of this, you will appreciate it. I guarantee you that. I guarantee you that. So with that, I have the distinct pleasure of introducing our moderator this evening, our own Vice President of Academic Affairs, Dr. Kathleen Jagger. Dr. Jagger has been the Vice President of Academic Affairs and the Dean of the College of Thomas More since 2015. She earned a bachelor's degree in zoology from DePaul University, a PhD in microbiology from the University of Cincinnati, and an MPH in international health from Harvard University. She has published in the areas of mechanisms of microbial diseases, improving science education, incorporating ethics into undergraduate biology curricula, and has led many international off-campus study courses. An advocate for both students and faculty, and a believer in the benefits of diversity for higher education, she has dozens of scientific publications and presentations, and has been recognized by University of Kentucky as a teacher who made a difference, by the American Society for Microbiology as a scholar in residence and foundation lecturer, and as an Eli Lilly faculty fellow, and as a Bingham Fellow for Excellence in Teaching. But for me, more importantly, I get to call her friend. So with that, Dr. Kathleen Jagger.
Well, along with the earlier welcomes tonight, I'd offer my own warm welcome to each of you, our community members, our students, our faculty, staff, alumni. I'm glad to have all of you here today. I think we are really in for a treat this evening with our three distinguished speakers, each of whom is an expert in various aspects, legal aspects of religious liberty debate. Those of you that are hesitating to sit in these seats, please come sit in them. You're welcome. I see. It says reserved, but if you're not here yet, those who's reserved for it, tough luck, come sit in the chair. Executive decision here. So each of these will be bringing to our conversation tonight divergent opinions and points of view. Certainly seeing what emerged last week in the news that the Department of Health and Human Services has created a new federal office on the conscience and religious freedom is evidence that indeed we are at a crossroads of religious liberty, and that the questions which will be raised this evening are not merely an academic exercise, but matters with practical consequences for our workplaces and for our pluralistic religious society that we live in here in the U.S. I would like to briefly introduce each of the speakers now, so as not to interrupt the flow of the presentation and the discussions to follow. Your programs will have more comprehensive descriptions of the extraordinary careers of each of our speakers. I will merely hit a few of the highlights. All three are experienced practitioners of law, prolific writers, inspiring teachers, recognized scholars, and frequent speakers on the topic of religious liberty. Kevin Walsh received his bachelor's degree from Dartmouth College and a master's in theological studies from Notre Dame. Today he comes to us from the University of Richmond School of Law. His scholarship focuses on the scope of federal judicial power. He's a Harvard Law graduate, and he's clerked for several judges, including Justice Antonin Scalia of the U.S. Supreme Court. He was on the original legal team in the Little Sisters of the Poor case against the contraceptives mandate. And then for each speaker, besides the very, very short abbreviated bio, I'm just going to give you some scaffolding on which, especially the students, to hang all of this together. So I'm going to give you a few of the things that they're going to be focusing on. In his keynote address, Mr. Walsh will be providing the context for litigation that has occurred in the last 25 years since the Religious Freedom Reformation Act, or RFRA, was enacted. And he will put an emphasis, I think, on the most recent 5 years. He will also be examining the relationship of religious liberty to the administrative state. Our next speaker, Fred Gedicks, earned his bachelor's in economics from Brigham Young University and his JD from the University of Southern California. Go Trojans, I have a sister that went there. He's currently a professor from the J. Reuben Clark Law School at Brigham Young University. He has lectured internationally and offered workshops at a number of law schools. He was an assistant counsel to Gore in the Utah primary and general election campaign in 1999 and 2000. Mr. Gedicks will present a little bit about how to think about religious exemption, including perhaps something about Kant's categorical imperative. He will also consider religious liberty as it impacts nonprofits versus those operating in the public space. He would also like the audience to consider how we can protect religious liberty without creating additional ancillary problems. Ilya Shapiro earned his bachelor's degree from Princeton University and an MSc from the London School of Economics. His JD is from the University of Chicago. He's currently a senior fellow in constitutional studies at the Cato Institute and editor of the Cato Supreme Court Review. He's testified before Congress and state legislatures. He's filed hundreds of amicus briefs, and he lectures regularly on behalf of the Federalist Society. I think he also worked on the policy staff of Bush Cheney, right, in 2004. So all of these speakers are, engaged community members as well as accomplished in their own discipline. Mr. Shapiro will argue that through an ever-expanding list of mandates and regulations, the government squeezes out civil society and foments social conflict. But natural and constitutional rights have to trump positive and statutory ones. So there's no justification for forcing someone to do something they don't wish to do, particularly in expressive contexts, absent some kind of emergency or monopoly situation. It actually all goes back to the old English common law conceptions of public accommodations, so there doesn't have to be a conflict between religious liberty and gay rights or anything else. So to begin with our speakers, please help me welcome to the podium Mr. Kevin Walsh to offer the keynote address.
Thank you, Dean Jagger and President Armstrong, board members of the Institute for Religious Liberty, and to all of you for being here. Especially thank you to Dr. Hebert for bringing us all together this evening. I'm glad that our topic is no longer such a hot topic, but hopefully we won't be boring. We'll keep it interesting. Because one of the things you'll see is that there are a lot of different ways to think about religious liberty. And I know that I think about it differently from the other speakers here, and we don't exhaust the range of possibilities. But congratulations on this institute. I expect it will do great things, and I'm glad that you took a little time before you got all the lawyers involved, because that was one of my themes is that. This is for those of you who have to write reflection papers. I'll tell you what my themes are. Because if I I had students and I wanted them to come, I'd make a reflection paper. So here's some red meat for you. Actually, let's just wait. Let me give you the roadmap. There's 3 things I want to talk about, or 3 kind of areas. One is to just situate the legal perspective on religious liberty as compared with other ways to think about religious liberty. The legal perspective is not the only one. It's not, in my view, the most important one. But it is important when you need a lawyer. So that's just the bigger context. The second is to actually talk about some cases. So what are the big Supreme Court cases in the last few years, and how do they relate to some of the other things that have been going on at the court and in lower courts? And then third, a kind of looking forward, or where are we now? Our title is Religious Liberty at a Crossroads, and I'll focus on 3 different intersections. So those are the 3 parts. So let's just situate this for a second and think about this first thing, the legal perspective. Theme 1, okay? If you're litigating, you're losing. Okay, that's one perspective on religious liberty. That's not always the case. There is, but for certain types of religious liberty claims, including those that are trying to be preservative of what happened before some other legal change, if you're litigating, you're losing. So it's not universal truth, but it's generally true for normal people, right? When you have to go get a lawyer, and that lawyer has to go represent you in court, something bad has happened, and you need to either there as a defendant, right? Someone has sued you, the government has sued you, or some other private party whose rights they say you violated. So you're there as a defendant, or you're there as a plaintiff. But even as a plaintiff, right? That's who initiates the suit. You know, there's better places to be. Let me tell you, I was speaking with Mother Lorraine, who's the provincial for the province that I live in, for the Little Sisters of the Poor, and she said, we'll be praying for you, and she said, you know, I wish we could be there, and I wish some of the sisters from the Cincinnati home could be there. And I said, Mother Lorraine, you don't need to be there because you have your ministry, right? The fact that you're at the center of these lawsuits in some ways is unfortunate. You should be doing your ministry, your sisters should be doing their ministry, not hitting the legal discussion circuit, right? Because when you're in litigation, that has costs. You have to be on the phone, you have to do different things. So it's much better, wouldn't it be much better if you lived in a society where you didn't have to go to court to preserve your integrity, to act in accordance with your conscience? And this isn't true for all litigation. A lot of social movement litigation, a lot of your controversial things, you have groups that are really trying to move the law, to change the law. And so this doesn't apply there. But generally speaking, for normal people, if you're litigating, you're losing. And this can be true even if you're winning your cases. Because you'll hear the religious liberty claimants in these cases have largely won in recent years. But religious exemptions are often thought about, just think about the word exemption. It's often thought of, you want special rules, right? The regular law doesn't apply to you. And no one in America likes people getting special treatment. And so if you're in the position of kind of winning something that will be cast as, oh, the law doesn't apply to you, well, that's not a great position to be in the long term. Again, even if you win. So that's the broader perspective, I think, on litigation. So now let's move to some of the cases. Okay, so I've got 5 here Supreme Court cases. These kind of go in chronological order. The first is the Hobby Lobby case. Okay, so this was an outgrowth of the contraceptives mandate, as President Armstrong mentioned. So the Affordable Care Act is passed and includes a statutory provision that says you're going to need to include preventive services for women. What does that mean? Well, we've got agencies to figure that out. That's why we've got an administrative state. They can figure out what goes in that bucket, but you got to fill that bucket. Okay, so then it went to some agencies. The agencies then farmed it out to a group called the Institute of Medicine, which is a specialty body. The Institute of Medicine said, among all the other things that you should have, includes all FDA-approved contraceptives, and counseling and the like. So then that recommendation was accepted by the government. The government then put that into a rule. But there's another law, not just the ACA. There's another statute called the Religious Freedom Restoration Act. It was enacted in 1993. And I'll say a little bit more about some of that history. But it applies to everything the federal government does. It used to apply to state and local governments. It was held unconstitutional for reasons that have nothing to do with religious liberty. But the federal government has to comply with the RFRA, Religious Freedom Restoration Act. There's a law review article. I like the title because it's descriptive and not just memorable. A RFRA runs through it. Right? That's what the federal code is, the sort of, right? Every implementation of every law. So we knew that there would be some religious exemption to something that you can predict there's going to be a religious objection to. There's an obligation on the government then to sort of figure out, is this going to be a substantial burden on the exercise of anyone's religion? Because if it is, they have to figure out, is there another way we can accomplish our goal? It's got to be a really important goal. The legal term is a compelling interest. And then your method of reaching that compelling interest has to be narrowly tailored. And is there some way that we can accomplish our goal, in this case of providing essential preventive services for women, without burdening someone's exercise of religion? Okay, so there was going to be an exemption. The rule was announced. There was an exemption. It was really narrow from my perspective. And so there was an outcry. And this was sufficient, and it included, by the way, Senate Democrats. And there was fights in the White House about the scope of the exemption. So President Obama announced we're going to have another process, right? So some lawsuits were filed because they say we're not going to be covered by the exemption. And then the president changes course and says we're going to have something else. And then some other lawsuits were filed during that process. That's when the Little Sisters first started coming into the news. And you know, our thinking, which, by the way, I'm still representing them. I'm not the most important person on their legal team, but everything I say is my views, not theirs. I'm not here as a lawyer for the Little Sisters. And I'm not revealing any confidence by telling you that we decided to wait. There was no need to file a lawsuit when the second process was ongoing because you hoped there'd be an accommodation. The accommodation came out, and the sisters were not going to be able to comply with that either. That's when that lawsuit was filed. All of which is to say, while that was going on, the process...
Any of you who are lawyers or want to be lawyers, Kevin is leaving out a very important continuing legal education point, which is always try to have as your client, especially on the plaintiff side, the Little Sisters of the Poor. Very good.
This is true. By the way, there's all sorts of Little Sisters of the Poor stories, but there was a university president who didn't know that they were an actual legal order because in college football, they're like a metaphor for a weak opponent. So, this guy was, what university was he? But he's like, TCU, they play in the Little Sisters of the Poor. And then he found out that they existed, and then he raised a lot of money for them. So anyhow, while the nonprofit stuff was going on, okay, they weren't, the for-profit companies were not going to be eligible for an exemption, and they weren't, no accommodation was going to be on the table for them. That's why Hobby Lobby came first, okay, because there was no exemption, no accommodation, and this also goes for litigation strategy, as Ilya mentioned. It was no mistake from the government lawyers and the administration, knowing that litigation is coming, knowing that it's going to be nationwide, you absolutely do not want the Little Sisters to be the first case. You don't want it to be any case. But if you're going to have a case, you want your first one to be a big for-profit corporation. Preferably, something that can, look, this takes place in a context, that matter. But the interesting thing about Hobby Lobby, and don't worry, my other four will go faster, I just need to give you the context of this mandate background. The interesting thing about the Hobby Lobby case and the way the government litigated it is that the primary issue was whether the Religious Freedom Restoration Act even protected for-profit corporations like Hobby Lobby. So it was a legal question, the meaning of the word person. The other stuff was in there, but the administration spent most of its time trying to win by saying that they're not protected. The Supreme Court, by a 5-4 vote, held that the Religious Freedom Restoration Act did indeed protect corporations, which, by the way, is not surprising. A lot of churches are corporations, so it was really the for-profit corporation point. So they were protected. They found that compelling them to add the materials to their coverage, they didn't object to all contraceptives, just those that they thought to be abortifacient. So there were, I think, 4 out of 22 that they identified. That compelling them to provide coverage for that was a substantial burden on the exercise of their religion. They said, we're going to assume, for the sake of argument, that the health interests that are being served are compelling. They just said, we'll just assume that, because even if that is a compelling interest, the last part wasn't satisfied. There was another way of accomplishing your goal. So 5-4, very good for the cases that would come after, but they weren't controlled by the Hobby Lobby case, because the accommodation that came out was different from the mandate itself. So we had a separate issue in the Little Sisters case when it actually came up as to whether they had already provided, they'd lifted the substantial burden. Okay, but first I just want you to know, Hobby Lobby 5-4, okay, big thing. Next year, okay, this is now outside the mandate, is a case called Holt versus Hobbs, 2015. This was a 9-0 decision. This is a more typical religious freedom claim. It actually arose under a federal statute called RLUIPA, R-L-U-I-P-A. Remember how I said RFRA was struck down as applied to state and local governments. So after that, they passed a law that regulated land use decisions in prisons because of the way it fits with Congress's power under spending and other ways. So point is, RFRA-style rule, but limited to, in this case, land use in prison. This was a prisoner, Muslim prisoner, wanted to grow a 1/4 inch beard. 1/4 inch is not long. This was Arkansas. But it was covered by federal law. Arkansas sometimes allowed beards for medical purposes, so there were some exemptions built in, but not for this religious purpose. Fascinating thing about this case, the guy's petition to the Supreme Court was handwritten. And Justice Alito issued a stay of the lower court ruling, so he sued and lost, and he went to the Supreme Court. Justice Alito issued a stay, it went up to the Supreme Court, 9-0. It was like a religious liberty love fest. Everyone realized that the prison, because what happens in a lot of these cases is you say, really, what is your interest? Oh, security. Okay, so I guess you make everyone shave their head, right? You can't, because if you can hide something in a beard, you can hide something in your hair, right? And, Justice Alito asked the question, like, what do you think that, it was, I'd rather not have been the lawyer for the state, because it was 9-0. So a lot of times in religious liberty, we actually find broad common ground. This was 9-0, even if it takes getting to the Supreme Court to win your case. Next year, 2016, I call it the Little Sisters case because they were my clients. The name of the case was Zubik because there were a whole bunch of cases. And Zubik is the kind of person the administration would rather have on the other side. Archbishop Zubik, right? Because if it's the Archbishop and clerics versus women, politically, that's not good for the Archbishop. So Zubik, I'll call it the Little Sisters case. Terrible thing, right? By the way, it was a unanimous decision. 8-0. What? Right? Everyone thought it would be 5-4. Including, everyone thought it would be 5-4. A month before oral argument, Justice Scalia passed away. The court that heard the Zubik case only had 8 justices on it. Some of those cases that people thought were going to go 5-4, they ended up as 4-4 cases, in which case the lower court decision is going to be affirmed because they didn't do anything. It was just 4-4, so you can't get a majority. This was a very curious decision by the Supreme Court. What they said, and the reason they were able to get it unanimous was by kind of a compromise in some ways, and we're not going to speculate, but essentially what they said is, litigation positions have moved somewhat during the course of this, and we actually think there might be a way to do what you did with the accommodation without without making these organizations sign the kinds of statements and execute the kinds of documents that you're making them execute under the accommodation, we think you still might be able to provide insurance coverage. And I haven't gone into all the details just because this isn't only about those cases. But what you need to know is they said some things have changed, so we're going to wipe out all the lower court cases that have happened and work it out. Okay, so that's why our case is still alive. Some of these cases have settled, but something else happened in 2016. Presidential election. Right? Remember how I said this stuff has a political context? Well, the new administration has a different approach, right, to religious liberty, and it's very rare that your clients get invited to a Rose Garden ceremony, but they did, and sure enough, there was Mother Lorraine and others, and the President of the United States says, you won. I'm paraphrasing, but this is over. Well, I don't know if you've been fully briefed because we're still going, right? But when the President says you won, my view is you won, and then everyone else will figure out how to do it. Now,
tired of winning?
what's that?
Tired of winning?
You're going to win so much. Actually, we were tired. So anyhow, so there's a new regulation, and I'll say a little bit more about that process. But essentially, the exemption that we were asking for, that the churches got, the thing that was initially we weren't eligible for, we're now eligible for a full exemption under a new rule. That new rule itself is subject to challenge in some other cases. Okay, two more quick cases, real fast, and then move out of the mandate thing. Next case called Trinity Lutheran. This is the only case actually involving the free exercise clause of the Constitution. This was a nursery school playground at a nursery school that was run by a church. And Missouri, like many states, has a provision in its Constitution that says essentially no funds can go to a church. Now, the funds that they wanted were from this scrap tire program. So if when you get your tires changed, there's like a checkoff, actually not a checkoff, a separate charge that goes into some scrap tire fund that then they recycle the tires and whatever. This nursery school qualified to get essentially money to pay for rubberizing using the recycled tires for their playground surface. And they were going to win it. And then a lawyer got involved, see? And they said, hold on, awarding this will violate the Missouri Constitution. So they said, sorry, we can't violate the Constitution. So this being America, what you do, you sue. So they didn't get their grant, but they got their lawsuit, and they eventually prevailed, right? They had lost below, but the Supreme Court, this one was a 7-2 decision. And by the way, the only decision in the Roberts Court on free exercise or establishment clause that is not either 5-4 or unanimous. I was going to say 9-0, but we had the 8-0. So maybe things are thawing, who knows? But it was a 7-2 decision. The Supreme Court, they didn't all agree on the rationale, but they essentially said, look, it's a playground. We're not talking about direct funding for different kinds of things. One of the rules is you can't treat people worse when it comes to a generally available public benefit just because they're a church or a religious organization. The devil is in the details on that line. Everyone agrees if the church is burning down, the fire department can put out the fire, right? Everyone agrees that if something bad is happening at a church, the police can protect you. That's your classic general benefit. But then there's other things, right? And where they drew that line was wide enough to include the playground resurfacing sort of thing because of the way the grant program was structured. But looking forward for free exercise, this is where the action is going to be, is things like vouchers, things like textbooks, historic preservation grants. They had a case in 2004 called Locke versus Davey, where they said it did not violate free exercise to say, hey, you can't use your state scholarship to study devotional theology. That did not violate free exercise. So basically what lawyers are arguing about going forward in some of these money cases and other grants, is this more like playground resurfacing, or is it more like money for theology? Those are some of the cases that will kind of percolate up. Last case I want to mention is a case called Masterpiece Cake Shop. It's not a free speech case, but it is one of these sort of culture wars things. In fact, you actually have a case here in Kentucky that will be heard by the Supreme Court of Kentucky involving a very similar issue. Masterpiece Cake Shop was a cake artist who, there's even reality shows about these guys that are not Masterpiece, but Cake Boss. But anyhow, so you had two men who, this was actually took place in 2012. They were going to get married in Massachusetts. They couldn't get married in Colorado because Colorado still required a man and a woman for marriage. But they were going to get married in Massachusetts, celebrate it in Colorado. They asked Jake Phillips to make a cake for them, and he basically said, no, there are certain things I won't do. In your case, I will not make a wedding cake for something that I don't understand to be marriage. Now, if they wanted something with alcohol in it, he wouldn't make it. If they wanted a Halloween cake, he wouldn't make it. This was due to his religious beliefs. But his saying was, this is not something that I will make custom for you. You can buy anything else here, but in terms of using my creative talents to send a message, he didn't put it that way. His lawyers have kind of explained the actions, and I think it makes a lot of sense. The name of the place was Masterpiece Cake Shop, after all, right? It's an expression. But that's technically the big issue. There's a free exercise claim, but the big issue there is free speech. His lead argument is expression. And so your Kentucky counterpart is one called Hands-On Originals. They are a custom t-shirt place who also denied I think it was a gay and lesbian student organization. So what we're looking at in those is what is the scope of the ability of, in this case, a creative professional to say, no, I won't take your custom order. There's some easy cases. We think, if you're a PR person, and you say, you know what, actually, I don't want to write a press release to support Scientology or whatever your thing is that you don't support. A lot of when people are doing the writing and journalists, they get it. But the big issue there was, how do we define what is expressive and what is not, and all of that. Okay, so that's our sort of overview. I had some lower court cases, but I think you've seen enough to get a feel for what's going on. What's interesting there, right, is that of those 5 cases, only one, as I mentioned, was free exercise. Right? 3 were statutory, and 1 is free speech. And that points to something else, which is, while constitutional law will be focused on the Trinity Lutheran, Locke versus Davey, and maybe some establishment clause things, when we think about religious freedom, most of this is actually at the level of statutes and regulations and the political culture more generally. So I'd like to conclude with some reflections on what's happening is there. Reflection paper time. 3 intersections. The first intersection is partisan politics and religious freedom claims. Okay? Second intersection is administrative implementation and general principles. And then the third is essentially popular culture, traditional media, social media versus sort of the actual law and the actual policy. So, partisan politics. It didn't used to be this way. The law of religious liberty was not always so polarizing. Remember that Religious Freedom Restoration Act? It was enacted 25 years ago. It was a voice vote in the House. Sometimes when you have voice votes, because people don't want to be recorded. But other times it's because everyone just pretty much agrees. So it's just like, yay, the ayes have it, okay? Any nays? No, okay. 97-3 in the Senate. And it was signed into law by President Bill Clinton. Okay? And the kinds of cases they had in mind were different from cases, actually probably by Christian organizations, majority-type organizations challenging government action. That's what's different about, say, a Hobby Lobby or Little Sisters. Cases they were thinking of were more like the prisoner cases, religious minorities, where people just weren't paying enough attention to religion. And also, it was trying to reverse by statute a very unpopular decision written by Justice Scalia. And what everyone could agree on, sort of religious conservatives didn't like the outcome, and religious liberals thought it didn't provide enough protection for religion, so everyone agreed Scalia was wrong. We needed to have a statute that provides more protection. Since then, we have seen an erosion of the kind of consensus across party lines that was on the value of religious liberty. That doesn't mean we've necessarily lost an agreement that once was. It's just that the law is now being invoked for different kinds of claims. And people realize how powerful RFRA is. And some organizations say, you know, if I'd have known you were going to make that kind of claim, I'm not sure if I would have supported that law. But to show you how political it's become, the latest mandate case that's going on right now. Remember that new rule I mentioned? It provided the exemption for nonprofits. State attorneys general, right, in democratic states or states of democratic attorney general, some of them have brought suit to challenge those exemptions. Okay, so in Virginia, we just had an attorney general election. I can assure you Virginia, which is a party to one of those challenges, would not be a party if the election had come out differently. So that's sort of the first intersection. It's become politicized and polarizing in a way that it wasn't until the last 10 years. Second intersection, administrative implementation and general principles. I'll probably leave some of this for the interchange that we're going to have, but basically remember how I said religious liberty, one way that it gets cast is special rules for me. They don't apply to the rules that apply to everyone else. But why not think about our general rule of religious liberty, like our RFRA runs through? Why not think of that as a general principle, right? In a free society, that seems like a good principle. If there's a way to not burden people's religion, let's try and do that as an alternative. So instead of thinking about this as special pleading, why not think about it as special attention to a special value that then gets operationalized in a way that forces the government to think about other ways and do it if they can. We don't have a RFRA culture in government right now. It's sort of more like the prison, which really, if they paid attention, they could have done it. They shouldn't have been in litigation. And then the third area is the intersection of popular culture and social media. This is a kind of more societal, sort of broadly societal version of that partisan polarization. In my view, there have been some misrepresentations that have been very hard to counter. For example, Dean Jagger mentioned the new office that HHS, Health and Human Services, is going to have for conscience protection. Well, I know some of the people. One was a law school classmate who's sort of implementing this. And there was a piece in a Washington thing called Politico, which was basically like how the evangelicals are taking over HHS, right? So it's internal to the government, people saying, look, now we've got these new political appointees, the evangelicals are throwing their weight around. It's a little interesting because I know, as I said, the one guy, and he's not evangelical. He's Catholic. Catholics and evangelicals, they're just different. But the point is, it's the narrative, right? Is the religious people, right? Now that they're throwing their weight around, and this is kind of, don't believe everything you see on Facebook and Twitter or in other places about religious liberty, because the PR that goes into this is this on both sides. As Ilya's mentioned, Little Sister Poor goes in. There's all sorts of framing that's going on. My worry, and the thing we ought to be worried about, is that those frames change and lead to kind of false framings that we don't even know they happened. And so when you're litigating, the litigation takes place in a larger culture that is changing. So to conclude, I would just say that we've won, the claimants for religious liberty have won the big cases in recent years. We've won the lawsuits, but we've lost by being involved in litigation. And we also ended up in litigation because we lost something else. And we, sort of broadly speaking, for this type of religious claimant, when you think about how to think about this, and you'll hear different from different speakers, my general rule, so this is a sort of litigating, you're losing, another reflection paper maybe, follow the force. Who is trying to use the coercive power of government to do what to whom? That is a good way, I think, to think about it. As you're looking for that, though, look for the problem solvers. Look for the people who are trying to figure out a way to get this done without having lawsuits. And then finally, just to put this all in perspective, the Little Sisters of the Poor, they are a global congregation. They had to leave China. They've had problems in France earlier in their history. They know what it's like to face off against the government, but they have a good relationship with the government, generally speaking. But what really matters for the Little Sisters of the Poor and for colleges and liberal arts education, pray for vocations, right? If you're a praying person, and this is what we need, right? To build up, like, keep in perspective, like, yeah, if you need a lawyer, get a good lawyer. But, you know, it's the free exercise of religion. You gotta exercise it, or else it goes away. And you don't have the government to blame, you don't have anyone to blame but yourself for not actually exercising your religion. So I'm glad the legal perspective was not the first one. It's an important one, but keep the legal perspective in perspective. Thank you.
Thanks, Kevin. And next we're going to hear from Fred Gedicks.
I'm really pleased to be here. It's traditional to begin your talk with thanking a long list of people, and I thought instead of doing that, I would just tell you a really brief story that indicates how generous the college has been to me. One of your students, Cameron, here on the first row. I should also express solidarity with the people who voluntarily sitting on the first row. I'm a backup person myself. As many of you know, Mormons don't drink coffee, but it's not like we're genetically immune to being tired early in the morning or late at night when we have things to do, and so we just have to caffeinate ourselves in other ways. And my preferred method is energy drinks. You don't usually go somewhere and have energy drinks out there. You know, it's iced tea, it's coffee, or whatever. So Cameron comes into the student commons today where I was working, and you know, asked me if there's anything he could do for me. And I said, is there any way I could get an energy drink? And he tells me, you know, I saw that you're a Mormon, and I saw that you're a law professor, and I thought, this guy must survive on energy drinks. So, yes, I do. I have one right here. So thank you, Cameron, and thanks to the college for this invitation. It's always difficult to be a respondent when you share a great deal of what the person responding you to talks about. These are really complex issues. Complex in the sense that, you know, the cliche sense in which you pull on a string and then all of a sudden the whole fabric starts to unravel and everything's interconnected. So I just want to sketch maybe one alternate, not really alternate, but another piece of the picture that Professor Walsh has sketched to help us have a richer understanding of what's happening here. Instead of religious liberty at the crossroads, our discussion might have been titled, Protecting Religious Liberty While Minimizing Its Collateral Damage. Because I think that's the crossroads that we're confronted with, whether to relieve believers of obligations under general laws when these laws provide protections and benefits to those of other faiths or no faith at all. That's a dimension of religious liberty too, to be able to live out your life without being burdened by the religious commitments of others. This is usually referred to as the problem of third-party burdens, third parties being those who are affected negatively by exemptions but don't share or practice the exempted faith. Hobby Lobby presented this issue. Hobby Lobby wanted a categorical exemption. They didn't want an accommodation in which women would get contraception while they were removed from the process. They just wanted what they have now, which is they raise their hand and say, we object to providing these contraceptives in our insurance plan, and that's that. They're out, and women and female dependents of Hobby Lobby employees are now left to provide their own contraceptives with after-tax wages outside of the insurance plan. I mean, in a very real sense, you can say that Hobby Lobby employees are paying for the boss's beliefs. Now, what was, I think, especially telling and dispiriting during the Hobby Lobby litigation, I did not represent anyone in the Hobby Lobby case, except a bunch of law professors who filed an amicus brief, which got some attention. There was, well, I will simply say that Hobby Lobby and that side of the litigation was completely unconcerned about removing a valuable entitlement from its employees. I mean, it was about them. It was about their religious beliefs. And there was, ultimately the court reached what at the time was sort of a Solomonic compromise. Actually, it's not a Solomonic compromise because, you know, dividing a child in half is not a brilliant compromise, but it was nevertheless a compromise in which an already existing accommodation for nonprofits was extended to for-profit corporations, and Hobby Lobby was relieved of the obligation of arranging for coverage of the objectionable contraceptives in its insurance plan, and yet through some incredibly complicated regulatory machinations which would keep us here until midnight. Just trust me, women ended up getting the contraceptives under the same circumstances at the same cost as they would have gotten had they been covered by their insurance plan. But Hobby Lobby wasn't interested in that sort of compromise, and to be honest, neither was the government. I'll just add editorially that the Department of Justice and the Solicitor General's office has done brilliantly in many cases, but this was not one of them. Very poorly litigated by the government, and the results reflect that. One of the deepest ironies is in the many debates I did with folks from the Beckett Fund and folks on the other side of the issue. I would raise the third-party burden issue and say, well, what about that? How can we deal with that problem? Is it really the case that you're entitled to a religious exemption that is going to burden other people? Is it really the case that you're entitled to exercise your religion at the expense of people who don't even share your beliefs about contraception or indeed anything else? Is that what religious liberty is? And the response was, well, the government can provide it. The government can do it. And that actually is, I think that's true. If we had single-payer government-funded health care, then all these issues would go away. We'd have other issues to be sure, but certainly we wouldn't have any problem with a contraception mandate because the government would provide it, and that would be that. We would cut out private entities. But what's stunning about this, what was stunning about it, is that the coalition that is pushing for religious exemptions under RFRA and under other statutes and in certain cases under state constitutional and occasionally federal constitutional provisions is the coalition that almost precisely coincides with the political coalition that wants to eliminate Title X funding of contraceptives distributed through organizations like Planned Parenthood, which they're attempting to defund, wants to reduce benefits under Medicaid, through which one could distribute contraception. And so I'll just be polite and call it an irony. The irony of this coalition saying, well, the government can do it at the same time that most members of this coalition across the street are actually trying to kill government funding. I mean, I think that's troubling. We all live together in society. We have a pluralistic society, even a radically pluralistic society. And if we expect people to accommodate us, we need to accommodate them. I certainly agree with Kevin strongly agree that litigation is the worst place to do this, because there's a winner and there's a loser. It's not designed for compromise. And there was a time when you could find compromises in the legislature, as he also says, and I hope those times will come again, but those aren't the times we live in now. Our political parties are deeply polarized, and they have become more univocal. They used to actually be conservative Democrats and liberal and moderate Republicans, and there are a few left in each party, but not very many. The overlap of the parties is much reduced. So when we talk about religious liberty now, I hear religious leaders talk a lot about religious liberty, and including the leaders of my church. And you hear it again and again and again. Religious liberty is under threat. It's under assault. And after a while, you understand what they're actually saying is we should be able to run our organizations without government interference. And this is never said, but it's always implied, regardless of the consequences for others. We should be able to sign our priests how we want. That's an internal church decision, regardless of the consequences for, say, sexual abuse. We should, well, what I'm getting at here is, reflexively in the United States, our conception of freedom is libertarian. That is, freedom is the absence of government. And as we see in case after case after case, that for many people, particularly religious minorities, racial minorities, women and children, liberty is achieved through the government. Private life, civil society, when the government is not present in those areas, then vulnerable people are left exposed to the powerful, who traditionally have been white or male, or the owners of capital, often all three. So calling the family private leaves women and children exposed to sexual and physical abuse by men. Until we finally decided, no, the family's not that private. If you're doing those sorts of things, then the government can intervene. And it's the presence of government in family life that prevents those sorts of horrible things. It's the presence of government in certain kinds of church decisions that we hope will at least prevent in the future some of the clergy abuse scandals which have plagued all religions, some more than others, but certainly all. Businesses are private property, and the people who own them can run them as if they're private property, except in certain areas where the government is present. So you cannot discriminate on the basis of race or gender or national origin when you hire your employees, even though it's your business and your private property. And it's the absence of government that permitted that to take place for too many years in the United States, and it's the presence of government that started to eliminate it. So I want to suggest here that this other side of religious liberty, that it is true that government is requiring many religious organizations and religious individuals to do things that violate their consciences. I think in some cases, as Kevin mentioned, the government's justifications for doing so are just silly. Justice Alito asked in the prison case if somehow the prisoner was going to hide a tiny derringer in his beard that he would pull out and shoot people with. I mean, it was just absurd. The government had literally no interest. But in many cases, often the 5-4 cases, these are the cases when granting a religious exemption is going to result in meaningful, measurable, substantial harm to other people who derive no benefit from the exemption. And those are cases that involve religious liberty too, and they need to be part of the equation as well. Thank you.
Thank you, Fred. And now for Ilya's comments.
Thanks very much to Thomas More, Professor Adair, President Armstrong, Vice President Jagger. That was a very nice introduction that she gave for all of us. I think we can now count that as moves like Jagger, right? But it's my pleasure to speak at your fine institution. One of my favorite movies is A Man for All Seasons, the chronicle of the life of Thomas More, and so it's I like having that kind of resonance when I speak. Although I did notice to my dismay, both at our dinner beforehand and tonight at this event, that I was expecting some big barrels of sacramental wine or what have you. And it's to my dismay, not just because I like wine, which I do, but I find that the more my audience has to drink, the wittier I am. So we'll have to somehow make do without. Although I think we should I'll try to make that easier because going along with Kevin's theme about if you're litigating, you're losing. I'm a recovering lawyer. It's been more than a decade since my last billable hour, and so my remarks will be in English rather than legalese. I appreciate it. And also, I find myself in the unique position as the kind of representative of agnostics or atheists. I'm not exactly sure, which I guess by definition makes me agnostic. Or you can call me Jew-ish, I guess. I often get invited to speak on religious liberty, even though I don't really exercise it. But it's very important because I think liberty in general is indivisible. There are some people who prefer economic liberty, or some people who prefer social liberty, civil liberty, all these different things. To me, it's one nut, and once you start kind of separating it, then the whole thing is in danger, depending on who's in power and what they want to oppress. And so that's why all of these issues that have come up in these cases that have been raised is a microcosm of the modern battles. These modern battles are a microcosm of the constant tension between civil society and an overweening regulatory state. These cases, Hobby Lobby, Zubik, Little Sisters, Masterpiece Cake Shop, they're not ultimately about the freedom to use legal contraceptives or the power of big business or small business, or even about how to balance religious liberty against other constitutional considerations. None of these cases entail an expansion of corporate rights or a weighing of religious exercise versus the right to use birth control or to engage in have a gay marriage or anything like that. But Justice Ginsburg, in her dissent in Hobby Lobby, paints a different picture, which I think is where we get this tension. According to her, by refusing to pay for certain kinds of contraceptives, employers were imposing their religious beliefs on their employees. Now, after the Hobby Lobby ruling, Bloomberg View columnist Megan McArdle noted that these cases, contraceptive cases, the latest strain of religious liberty cases, present the unusual situation in which both sides think that someone else's views are being imposed on them. Normally, in political disputes, debates are over the economic or moral justifications for particular policies, weighing the costs and benefits, the regulatory benefits, the economic costs, and what have you. But here, one side was saying that not paying for contraceptives is equivalent to imposing religious beliefs, while the other side says that the coercion lies in being forced to buy something that you don't want to buy. While we can argue about whether it's a good idea to require people to buy certain goods or services, whether they be contraceptives or otherwise, I think it's pretty clear that Obamacare does indeed force employers to do so. An exemption from that mandate is hardly coercive, and such an exemption would harm third parties only if we have a conception that those third parties have a right to force others to pay for goods or services that they want. And it's that if that's the crux of the matter here, and not just as it relates to Obamacare or gender equality or anything else. Americans have become so used to government providing all manner of goods and services and benefits that resisting state action begins to look anomalous. The right to freely exercise religion, among other individual liberties, is thus an exception to the general rule, which is government power. The left's outcry over religious free exercise is evidence of a more insidious process, whereby the government foments social conflict as it expands into more and more areas of life that we used to consider public, but not governmental. This conflict is exceptionally fierce because, as McCardle put it, quote, the long compromise worked out between state and religious groups, do what you want within very broad limits, but don't expect the state to promote it, is breaking down in the face of a shift in the way we view rights and the role of government in public life. So it's government's relationship with private life that is changing, and to public life, in places that are beyond the intimacies of the home, but still far removed from the state, like charities and social clubs and small businesses, and even so-called public corporations that are nevertheless part of the private sector. They're called public because the public can buy shares. Through an ever-growing list of mandates and rules and so-called rights, statutory positive rights, the government is regulating away the little platoons of our civil society, religious and otherwise. That civil society, which has been so important to America's character, is being smothered by an ever-growing administrative state that, in the name of fairness and equality, takes away rights in order to standardize American life from cradle to grave. And so these cases that have been discussed are just the latest example of the difficulties inherent in turning healthcare and our economy more broadly over to the government. It represents a larger, more destructive trend that's been enabled by the Supreme Court's ratification of expansive federal power, reading the General Welfare Clause, for example, as a grant rather than a restriction of authority. General welfare, that provision in the Constitution meant that whatever Congress does has to be in the general, not regional or parochial welfare. Instead, it's now read as whatever you get a majority for in Congress is de facto for the general welfare. Or applying the Interstate Commerce Clause to intrastate non-commerce. The assumption underlying these expansions is what Representative Barney Frank told the 2012 Democratic National Convention. Quote, government is simply the name we give to the things we choose to do together. Well, the problem here is that when something is socialized or treated as a public utility, we're forced to fight for every carve-out of freedom from those rules. So the more we choose to do together, as it were, through the coercive hand of the state, then the less we do in our private capacities, either together or separately. Historically, this squeezing out has been rather direct and obvious, a function of conventional political arguments over taxing and spending and redistribution, the proper size of government. But tax money can't go to consumer goods or political advocacy or anything else. It also can't go towards non-government education or healthcare. So government programs in those areas enjoy tremendous advantage over would-be competitors in the private sector. Government has thus moved past the conventional crowding out of civil society, narrowing the rules of the game such that private institutions are allowed to continue operating only if they follow a prescribed set of rules. And Obamacare is the apotheosis of this trend. It relies on conventional government expanding transfer payments, of course, but its heart is a list of shalls and shall nots that reshape the healthcare industry, and thus about a fifth of the economy. So critics of the Affordable Care Act frame Hobby Lobby as involving an attack on religious liberty. And while that's certainly correct with regards to the specific cases that reached the Supreme Court, the dispute is indicative of a much larger problem. Indeed, the Obama administration could have made all of these lawsuits go away. Hobby Lobby, Little Sisters, and all the rest of it. If it had simply decided to use one of the alternatives identified in Justice Alito's majority opinion in Hobby Lobby, or directed by the court in its per curiam unanimous opinion in Zubin. But the fact that the Justice Department chose instead to pursue a scorched earth strategy indicates that providing no-cost contraceptives is not the main motivation of the administration. Instead, the goal seems to have been to force religious employers to conform to that "we're all in this together" ethos. The decision not to compromise in any way is a shot across the bow of anyone who might deviate from this understanding of government's role in society. Progressives might cheer this coercion here. After all, it's in the right. It's the arc of justice, the arc of history bending towards justice. But they fail to appreciate the precedent that it sets, because the more that the federal government ventures onto the cultural battlefield in any capacity, in any arena, then the more both liberals and conservatives will issue mandates and regulations towards ideological ends. And it's through this kind of excessive regulation that the government stymies individual conscience and the voluntary institutions of civil society by conditioning participation in essential economic activity on the giving up of certain rights. The growing enforcement of centralized ideological conformity is the real innovation in the use of government power. The issue, again, is not Congress taxing or spending or borrowing more, but that forcing more mandates into what used to be private decision-making. And this is a shifting boundary between the private and the public sphere. We've heard talk about the, nobody wants to infringe the freedom to worship. Well, the freedom to worship is only a small part of the freedom of, to exercise your religion freely. To make matters worse, Justice Scalia, who was a devout Catholic, of course, laid the foundation for this particular problem. He wrote in the 1990 case, Employment Division versus Smith, "We have never held that an individual's religious beliefs excuse him from compliance with an otherwise valid law prohibiting conduct that the state is free to regulate." I actually think he's right there, that the Constitution does not read in religious exemptions. But for decades, the Supreme Court has neglected to draw a constitutional distinction between what the government can and can't regulate. So the problem is that the Constitution doesn't give the government the power to infringe on religious liberty in the first place, generally, in most cases. And it's that distinction that was at the heart of the contraceptive mandate litigation. And so the Catholic bishops who came out in favor of the Affordable Care Act at the beginning, their complaint about the government's enforcement of it against certain religious believers was right as far as it went. But pleading for that special exemption did not get them very far because, again, they supported it at the outset. They supported this idea of ever more expansion into civil society. Having supported that larger goal, the bishops can't be surprised that religious freedom was crushed along with many other liberties. Remember, as I said, whether it's economic liberties or property rights or the right to vote or anything else, all of these are one, to borrow a metaphor, bundle of sticks. And looking beyond Obamacare, we see the same thing in the spillover from the gay marriage debates, with people being fined for not working at same-sex ceremonies. I think there's a clear difference between the government treating everyone equally and forcing private individuals and businesses to support practices with which they disagree. After all, despite activists comparing that struggle to the civil rights movement, New Mexico and Colorado and Washington, all of these places where these wedding vendor cases come from, are not the Jim Crow South, where state-enforced segregation meant that black travelers had nowhere to eat or to stay. As long as those in power demand that people adopt politically correct beliefs or cease to engage in the public sphere, these issues will continue to arise. Education is another good example. The curricular battles over evolution and creationism, or the amount of time devoted to art versus science, or debates over methods of discipline or extracurriculars, could all be diffused if government simply allowed parents more choice over how to educate their kids and what kind of schools to send them to. Many of our culture wars are thus a direct result of the government trying to fit one-size-fits-all public policy onto a diverse nation. While the debate over the contraceptive mandate centers centered on a statutory safety valve. The larger matter of the government's rending of the social fabric remains. Indeed, Justice Ginsburg, in that Hobby Lobby dissent, even doubted the idea of exemptions from government regulations for anyone. But instead of concluding from her list of hypothetical situations that nobody should get exemptions from government mandates, I think the more obvious solution would be to allow everyone to have the same freedom to choose how to live his own life. Hobby Lobby was one case where the Supreme Court stood up for individual rights, but only on an unusual statutory exemption, and just barely. And the left's reaction to that ruling shows how little they understand, as Presidents Ford and Reagan said, that a government big enough to give you everything you want is powerful enough to take it all away. Or, as Madison wrote in Federalist 51, this is by far my favorite Federalist paper, I have a license plate that says Fed 51, quote, "You must first enable the government to control the governed, and in the next place oblige it to control itself." And that's exactly what the Constitution's enumerations of power were designed to do, limit power. That principle is simply no longer being enforced. And yet the most basic principle of a free society is that government can't force people to do things that violate their consciences. Americans understand this point intuitively. Some may argue that the contraceptive mandate cases or the wedding vendor cases or whatever comes down next have a conflict between religious freedom and reproductive freedom or gay rights or whatever, so government has to step in as referee. But as President Obama liked to say, that's a false choice. Without the HHS rule or without the forcing of the cake bakers to bake a cake, women are still free to obtain contraceptives, abortions, and anything else that's illegal. People are, gay married couples are still free to go down the street or go elsewhere online and get their cake. They just can't force someone to pay for it. The problem that these cases have exposed isn't that the rights of businesses are privileged over those of employees and customers. It's that no branch of government recognizes everyone's right to live life as he wishes. We largely agree, and I'll conclude with this, that certain things are collective needs that fall under the purvey of the federal government, things like the national defense, or clean air and water, and a few other such truly public goods in the Econ 101 sense. But most social programs and many economic regulations, and so much else that the government now promulgates, are subjects of bitter disagreements, precisely because these things implicate individual freedoms. The trouble is that when government grants us freedoms, instead of protecting them, the question of exactly what those freedoms are becomes less clear, and every liberty we thought we had is up for discussion, and regulation, and litigation. So those who supported the religious believers in the contraceptive mandate cases were rightly concerned that people are being forced to do what their deepest values prohibit. But that's all part of this new collectivized territory. Thank you.
Thank you, Ilya. So, do we have people here with cards for questions? Okay, we're good. All right, so we have a system that I just want to explain to those who haven't been here before. We're going to leave the mics on our tables. We have students that have index cards. If you have questions, just raise your hand. We'll get you an index card, write the questions, bring it out to our speakers. So while that's happening, if you have a question you'd like to ask, identify yourself so students can get around and get you those index cards. And while that's taking place, we're going to let our speakers have a follow-up comment or two to each other. So, who would like to begin? Kevin, you went first. You want to start again?
I got off the airplane. So when I got on the airplane in Richmond, it was about 51 degrees. It's 20 degrees cooler here. And I was reminded I'm in the Northwest, the old Northwest, right? Because
I thought you were going to make a joke about Thomas More, the man for all seasons. That's season here.
I'm saving that for you.
Okay.
But, you know,
I can't talk when Ripper runs through it. That's very
and it reminded me of the Northwest Ordinance. So there's 2 points I'd like to make. One has to do with the Northwest Ordinance and some broader historical perspective on how things have changed, because, and the other one has to do with baseline. So the first is, one narrative we've heard, overall, the arc is one of sort of increasing government, sort of collective support for things and a decrease in individual liberty. The Northwest Ordinance had a different way of thinking about this, and this was before the Bill of Rights, 1787. Let me just read you Article 3 of the last part of it. It said, "Religion, morality, and knowledge being necessary to good government and the happiness of mankind, schools and the means of education shall forever be encouraged." Okay, so religion, morality, and knowledge are so important that you're going to need schools, and the government's going to sort of encourage that sort of thing. The idea that we have public schools now for encouraging religion and morality and things, that has changed, right? So in one sense, there was, in some ways, more potential for government involvement in things because there was greater agreement on certain matters. So the government, its presence as a moralizer and things like that in schools has gone down in some ways, and that's a reaction to our pluralism. The second, though, is the baseline. So the big issue, right, is who's imposing on whom, right? Take the contraceptive mandate cases. So each side says, you're forcing your beliefs on me, or you're forcing me to buy something for someone that I don't want, something I don't want. And so this is a baseline issue. This happens in the law all the time, okay? And it's true that you're burdening employees who would not have no-cost access to contraceptives. That's a burden, right, if the baseline is one in which that's supplied, right, already. But see, what the government did in that case was it moved the baseline. It created a new entitlement. The Little Sisters of the Poor, their employees, they never had this coverage, okay? So nothing actually has changed. So when you're thinking about who's imposing what on whom, think about what the baseline is. Has that changed before litigation? As well as asking, instead of saying who is allowed to impose what on whom, you might want to say, again, who is using the coercive power of the government? And then, not what should the special rules for religious be, but what should our general rule be for dealing with, for the use of government force and coercion to make people do things that they otherwise don't want to do. That won't escape the baseline issue, but you should know that the baseline is there and very important to pay attention to.
Well, very briefly, I think the baseline issues are important. I just want to emphasize that baselines are not natural. They're chosen, they're constructed. So we have to choose a baseline. And so I don't think we're ever going to solve these issues by saying, well, it's just a baseline issue, because that's just to restate the issue. I think we ought to pay attention to where these things are happening, the site of accommodation. If you listen to Kevin and then listen to Ilya, you would probably be really surprised to learn that there was a substantial accommodation of religious nonprofits, which is different than the accommodation, than the exemption that Hobby Lobby was fighting for. Excuse me, that there was no exemption for Hobby Lobby, and the rhetoric here sounds as if there was no exemption for the Little Sisters, but there was a substantial accommodation for them. They weren't satisfied by it, and it involved a complicity case, and complicity cases are intractable. The only person who can decide whether a government action makes them complicit in something that their religion prohibits is that person, him or herself. The government can't adjudicate that. And complicity cases involve chains of causation that have, again, no natural limits. The Little Sisters case involved whether the head of the order had to sign a form. There's as many ways to characterize that form as there are people in the United States, but most, well, I believe most, but certainly a substantial number of Catholic and other religious nonprofits were satisfied with the accommodation. And, you know, at some point, when you live in a social welfare state, I mean, and that's what we live in, and we live in a social welfare state because
That's what Americans want. And religious liberty is a statutory right. I'll just close by saying, since it is a statutory right, if religious liberty means the ability to impose burdens on other people, and whether we can legalistically describe it as a burden or not, but I guarantee you, if I'm denied, if my family's denied contraception coverage because of my employer's religion, and my next door neighbor has it because her employer has a different religion, I'm not going to say, oh yeah, I understand, no big deal, a referee runs through it, my wife will just have to buy her IUD with my out-of-pocket wages or with her out-of-pocket wages. No, I'm going to feel like I'm being treated differently. If religious liberty sanctions that, then in the long run, I would predict that support for religious liberty, a statutory right, is going to dissolve.
But remember what the alternatives are. The alternative is not you having to pay for that out of pocket. It's the government deciding that this is so important that we're going to have lots of alternatives. We'll work out a separate deal with the insurer. We'll have a public program or subsidy or tax break for you to pay for it. And by the way, if that's public funding used for that, then the religious employer who doesn't want to cover it in his plan can't be exempt from paying the taxes that go towards that. So the question isn't whether you get your rights observed or not, it's whether it's absolutely necessary for the government to force someone in a particular way to do a particular thing. And so that's why I think the question that has to be asked in a lot of these questions is it absolutely necessary to force someone? So for example, if you have a truly important, compelling goal like eradicating systemic racial discrimination, say, there's no way to do that other than saying you can't discriminate based on race when you're hiring someone. There's no alternative to that. On the other hand, is it truly compelling to say that there can be no dissent from everyone who is a wedding vendor has to provide their services for a wedding they disagree with, whether that be a gay wedding or a second remarriage after divorce or interfaith or anything else? Is the government interest truly compelling, and really is there no other way of accomplishing that without forcing someone? I don't mean in terms of the legalistic standards, although that mirrors that, but just as a matter of basic first principles of this country. And that's why it's so sad that we've lost what Justice Ginsburg used to write a lot about in these free exercise cases, and that's the play in the joints. It's not, everything is free exercise until a certain point where it starts violating the Establishment Clause. No, some stuff that goes on involving religious questions aren't a litigious matter. And there I am circling back to Kevin's theme of if you're litigating, you're losing.
Great. Okay, we have some questions from the audience, and I'll just give one. I'll give you some others to look at as well. One person asked that we define burden. What constitutes burden? So I want to address what you were referring to in terms of how providing religious liberty introduces that third-party burden. Can you clarify what you were talking about there?
You're talking to me or to Kevin?
To you.
To you.
Yeah.
Shoot.
The burden's on you.
Indeed it is. As I said earlier, burdens are not natural. You can't go out and there's no way to decide that there are certain natural burdens. And even things that seem burdens that seem natural over time as society shifts, can seem unnatural and artificial and imposed. With respect to religious exemptions, because of the Employment Division versus Smith case, which Ilya mentioned, there is no presumptive constitutional right to an exemption from a religiously burdensome law. So exemptions are statutory rights, and so in the first instance, they're established democratically. I think also
they're established, what, historically or culturally? I mean, Ilya sketches this nirvana of America in which we only have a night watchman, and we can all work things out with our little pontoons floating around, insulating people from the government.
Platoons, but if they were on pontoons, that would be interesting. That's probably seasteading.
Yeah, platoons, I'm sorry. But that's not where we live. This is not 1840 or even 1875 or 1920. I mean, we had the New Deal, and there might be there is a constituency for rolling back the New Deal, but, and maybe someday it'll constitute a political majority, but one could say this is not that day. The third rail of politics is Social Security. We like our entitlements. We had a giant tax reform act, but the one thing that was not touched was the mortgage interest deduction, which is one of the craziest, most distorting things we have in the government. But most Americans, or at least most Americans who vote, own houses, and they like it. So I would suggest that we live in a social welfare state, and this has not been a sneak attack by by socialists. It's happened over time, and it's happened democratically. And so I would say, in conclusion, for-profit work sites is one of the most heavily regulated sites in the United States. There are a zillion regulations. And deciding that employer health programs should cover a certain minimum number of services is not out of the ordinary in what has happened over the last 100 years. Again, if it were 1875 or 1840 or 1787, you could say, whoa, where did this come from? It's like an alien spaceship that has landed from Mars. But it's not. This is where we live, and this is how we live. And so I would say the baseline includes entitlements, including new entitlements that the government enacts.
Kevin has
I mean,
something.
suppose we get a supermajority of Congress that thought guns were good and people are safer with more guns. And they passed a law, right, for the public safety that says your employer shall provide you, with certain types of funding as part, in addition to your compensation, and we'll give the employer a tax break for providing this kind of thing, but the ability to purchase, different kinds of weapons. Okay? And then there's some employers who object to that. They say, we're not going to include that coverage. Okay? Now, so you work for one of those employers, and suppose that actually we lived in a society where the employer could say, you know what, that's against my moral code, and therefore I'm not going to apply that coverage, and they can actually win. Okay? Is the employee of that employer burdened by not having the ability? No, that's not a burden. Right? So we can do things with intuitions, and now I picked guns because it's different from healthcare, but the point is it's not enough just to say, well, it's not natural, therefore, it's all fair game, and as long as the government puts it into an entitlement system, that becomes part of the new baseline. Right? So I think we can kind of try different things and say, would I feel burdened in that situation? Right? Is it fair to treat anything the government requires someone else to get for me as part of the baseline? That's the first thing. Second thing is in terms of actual burdens and an actual health effect. When the Institute of Medicine for the contraceptive mandate decided that it should be all FDA-approved contraceptives, they explicitly were not focused on the relationship between insurance coverage at no cost and, say, unintended pregnancies. There was some data that they looked at, but they took that to be outside their scope. And so they were just looking at unintended pregnancies are not good. FDA-approved contraceptives get approved because they're good at stopping pregnancies. Therefore, they should be included. It was the government's job then to figure out how that should fit into a mandate and how that fit in with RFRA and other things, and they never did that. And it turns out a study just came out, done by the Guttmacher Institute, affiliated with Planned Parenthood. So I mentioned that just because it's not the outcome they wanted. That is, there has been no change in contraceptive use or even the mixture, right? So some people, I won't go into it, but basically the ACA's contraceptive mandate has had no effect overall. And so a lot of this was for nothing. And the shame of it is that maybe if they had figured out this stuff ahead of time and looked more closely and drilled down in and didn't try and figure out, just like with our last government shutdown, right? These guys, they end up that way because they decide, both sides for whatever reason, usually one's wrong, but they think they're going to be better off. They can make the other guy look bad. And that's a lot of times what happens with our religious liberty. So if you're litigating, you're losing, but at least in law court, you get to make your case, and any sort of PR effect gets at least minimized because the lawyers have a chance to put their arguments in writing, and the courts are obliged to explain things.
Can I make a brief response
Sure.
to the gun hypothetical? I don't think the gun hypothetical is crazy at all if we lived in a culture in which government, in which employer-supplied guns were considered a natural and normal part of employee compensation. And of course, that's what health insurance is. Employees consider it compensation. They expect to get it. Now, there's no reason why they should expect to get it. The only reason it's supplied through employers, or the principal reason, is that it was a way to evade wage and price controls during World War II. But, you know, here we are. So, yeah, it's hard to imagine that world, but it's not impossible to imagine it. And if we lived in that kind of world, that would be the baseline.
Let's try another question here. Does providing sanctuary within the house of worship for an illegal immigrant, let's say otherwise law-abiding, fall under free exercise of religion?
Sure, that's
I should not have to answer that. Okay, answer the last part.
That's an easy one. There's no duty for the officials or employees of a religious place of worship to cooperate with federal immigration enforcement. There's no duty for state and local officials to do so either, unless they've accepted that duty. The strings coming with federal funds or something like that. That's the legal battle over sanctuary cities. But sure, it's if you want to shelter someone, and you can't lie to the police. That's obstruction of justice and things like that. So if you're asked a direct question by the FBI or whoever's coming to investigate, that's one thing. But just offering shelter or protection, not affirmatively ratting somebody out or what have you, that's not illegal.
I have another one, and then if you want to answer one that
Sure.
I've given you, you can. So, being that each person has different issues that are important to him or her, can they not choose employment accordingly? Why does every business have to provide a particular coverage, such as contraception or any other one, when each company varies on which benefits it provides?
I mean, ideally, that would be my situation. It's an accident of history that employers provide health care or health insurance in this country anyways, because we had wage and price controls during World War II, and so employers started competing based on various fringe benefits, one of which was medical care of various kinds, whether a doctor on premises or provision of that sort of thing. And no other country has, to my knowledge, ever provided health care that way. It should be, health insurance should be a market just like car insurance is or anything else, not through an employer. And other benefits similarly, you should be able to, people do compete on that. Apple offers lots of foosball tables. Google offers free food and, crazy bicycles or something to go around campus. Or, there's lots of different things that they compete on. And types of healthcare plans should be one of them.
Anybody want to address the question that you have?
I'll take one since I'm on a roll, I guess. So this question says, please compare the debate over having to include birth control in a health insurance plan to the use of tax dollars to buy the drugs and administer the death penalty, or to put citizens on a jury where the penalty could be death sentence for the defendant. Now that is a pretty easy question in the sense that I already sort of alluded to this. The comparable scenario to being paying taxes that go towards the death penalty or anything else that you might object to on religious, moral, or other grounds is the government using taxpayer dollars to pay for contraceptives or abortifacients or whatever that you might object to. So, which is not a valid claim. We don't get to say, well, I object to the use of tax dollars for that war or that social program or that subsidy to that corporation or anything like that. And you get to object to that through the political process. But once the decision has been made, you don't anymore. And so similarly, as I said in an earlier answer, if the Greens or the Little Sisters don't like their taxpayer dollars being used for the alternative health clinic where the government provides free medical devices they don't like, tough.
I've got another question. Go ahead. So I got two questions about Masterpiece Cake Shop. So we'll move off of the sisters and Band-Aids and all of that. I think
there's a lot of ways to slice that cake.
Sweet.
Only some of his theories are half-baked.
I'm going to keep talking now. So one is very, very straightforward. What do you think the result will be? Okay, great. We get to
5 to 4.
I agree. And then the other one, and I'll take both of them, is do you think it ought to be litigated as a free exercise rather than freedom of speech? How might that change the outcome? Well, it is. Actually, that one is a little more complicated. There's an easy answer and a hard answer. So first, on the outcome, yes, I do think it will be 5-4, barring some unusual thing. And so I do think Justice Kennedy will be on the freedom of speech side, probably. And therefore the cake artist will win. Some of his questions were that way. Let me just say, this area, so sometimes as a lawyer, you get an opinion that you win, but it doesn't make sense. Right? It's not good law, just in terms of general principles, and you think, I'm glad we won, but I didn't want to win that way, or I don't know what this means for future cases. And I do think you could end up with something like that. Some of the questions that Justice Kennedy was asking were generally favorable to the cake artist, unfavorable to the government, but they didn't really fit in some of them didn't really fit in pre-existing doctrinal categories. And so I don't know what the upshot of the case, even if it is 5-4 and in favor of the baker against the government, will, I don't know what its long-term impact will be, even if that's right. My confidence is somewhere above 50%, but below, say, 80%, because it really is what does Justice Kennedy think. There are a couple other off-ramps, right? So the Zubik case shows you that sometimes they can find ways to get an off-ramp from actually having to fully kind of resolve the issue. I have a favorite one that they'll go back and decide that this wasn't actually discrimination on the basis of sexual orientation, and therefore, which if it's not discrimination on the basis of sexual orientation, then they don't have to decide whether there's a federal defense for that. There's some problems with that, but the next one is, what is a free exercise rather than free speech? Well, look, a normal free exercise, it's going to be a losing case, right? Because the Smith case that you heard about, this is the case that RFRA was a response to. Ilya mentioned Justice Scalia's opinion for the court said, look, there is no general sort of, we've never held a free exercise entitles you to an judicially created exemption from a generally applicable rule. In that case, it was a prohibition on use of drugs. So notice, though, it's a sort of neutral and generally applicable rule, no religious exemptions. Now, generally speaking, your anti-discrimination laws, which is what he's charged with violating, those are going to be neutral and generally applicable laws. There is an argument in the case, and I think it's a pretty good one, that the way that the Colorado Civil Rights Commission is enforcing its civil rights laws makes the law not neutral, but in fact is viewpoint-based. And here's the argument. So Jake Phillips, says, that sends a message that I'm not comfortable sending. That's also why I reject he doesn't do bachelor party cakes. Someone asked him to do a divorce cake. He wouldn't do it. And so he has this sort of category of expression that he won't create. So some people went and asked some bakeries to write anti-gay messages. Okay, and some, there's sort of God abominates homosexuality or something like that. Now those were actual words. And so they said, the baker said, no, I won't do that. That's an offensive message. That's not something I want to be sending. And so the guy sued and said, you're discriminating against me on the basis of my religion. I was asking you to write a Bible verse. And you said no because you treat it as offensive. And so they said, well, that's not discrimination on the basis of religion. That's discrimination essentially on the basis of you being asked to send an offensive message. Now, if you think about it, expression, the boundaries can be hard, but you can express a lot without using particular words. So it can't be the presence or absence of words. So for example, the cake that was ultimately baked for this, when you sliced it, it had a rainbow design. It was a gay-friendly cell, which is just exactly as you'd expect. There's expression in there. So the argument on free exercise, in order to get out of the General Smith rule, which would make it a loser, is to say that it's in application, not generally applicable. I think you have to go through way more. I think they have to make a lot more decisions that go in the way of the baker to ultimately get there. So I do think, unless they have some sort of weird off-ramp with the statute, they're going to say it's protected speech. It's my guess.
I think one of the problems with Masterpiece Cake Shop is that the record is disputed. People are still unclear about what happened. Now that will stop the Supreme Court, even if we had a clear record and they wanted to go someplace the record didn't permit them to go. They usually go there anyway. But rather than argue about the particulars of this case, I want to make a broader observation, which is I think it's crazy that questions of religious conscience and anti-discrimination laws and LGBT rights are being litigated in the context of wedding vendor cases. Even the most unsuccessful people at marriage in the United States only need wedding vendor services 3 or 4 times in their entire life. And most of
monogamy now.
Most of us manage, with 1 or 2 weddings, right? There's civil marriage in the United States. There's non-religious marriage, but culturally, weddings in the United States are religiously charged. They have this religious component or aura to them, which makes it especially problematic to make people participate in them. Now, I do think that there have to be some limits. I mean, if you went to rent chairs and the person said, is this for a gay wedding? I don't want my chairs at a gay wedding because that implies my support for a gay wedding. I mean, I don't think that makes any sense. I think part of the problem with Masterpiece Cake Shop is that, I have 3 daughters, 3 wedding cakes. Hope it'll only be 3 wedding cakes. And I've been to a slew of weddings and wedding receptions, and I've never viewed a cake and thought, yeah, the baker endorses this marriage, this wedding. The baker is sending a message through the wedding cake. I personally don't think wedding cakes speak, even by implication. But if they do, it's the speech of the people who pay for them. And so I think there has to be some limit. And maybe the limit simply is that when a reasonable person would understand the service to involve a creative element, that will allow a religious exemption. But now I'm a white, male, straight guy, so I don't have standing to say this, but I'm going to say it anyway. If I were an LGBT activist, this is not the ground on which I would choose to fight. What matters, I think, to gays and lesbians, especially married gays and lesbians, is that they be able to get dependent and spousal coverage for their insurance. But, it could be there's a narrow opinion and there's an off-ramp, as Kevin suggests, but if there's
if there's a principle in there that is not limited to the facts, then you could find someone saying, you know, it's against my religion to fund, to provide spousal benefits for gays and lesbians. There's no, at least by its terms, although it's being litigated, there's no anti-discrimination protections in federal law against employment discrimination. Some people argue that discrimination on the basis of sexual orientation is sex discrimination, and the Trump administration at least has rejected that interpretation. And I think, do we have a
Circus split on that now?
There might be.
On which one?
On
Oh, I don't think there's a split
using
yet.
sex in Title VII.
I don't think there's a split yet, but
There'll be
Seventh
one.
Circuit, yeah, there'll be one.
Some will. I mean, those are the areas, I think, that where we need to work this out, and to be working it out in when it's just exactly backwards. It's like taking this really small area of life. Ilya's right. There's no Jim Crow regime in wedding vendor services. And there's not threatening to be one. And I suppose even if there were one, I mean, how hard is it to get a cake baked by someone? I mean, how hard is it to call up and say, do you do Mormon weddings? You know, I lived in the Deep South. I assume there were some folks down there who didn't want to do a Mormon wedding and might have said no. Well, that's not very pleasant, but 3 daughters, it only would have happened 3 times. So I just think there's something just weird about these cases. I think that they're so important.
Well, I mean, I think it actually goes to the bigger issue, which is the cases are about sending a message and to making sure that expression like "I will not provide that" is driven from the public square, so that treating my same-sex marriage as in the same category as a divorce, or in the same category as a second marriage, or in the same category as a bachelor party, all these things that you have a moral objection to, you are not allowed to express that because of the message that it sends. And so we need the government to use the anti-discrimination laws to say that that is just like saying, I will not bake your cake because of your race. And so I think it's very much, it's that's the whole point, is to equate the understanding of conjugal marriage as the union of a husband and wife with to take that belief, which is, just as Kennedy said, a lot of good and reasonable people hold that belief, and to treat it as the equivalent to opposition to interracial marriage, and because that needs to be driven from the public square. That's the whole point, and it's an expressive point. And that the material harm is not small. There is dignitary harm, undoubted, real harm in someone expressing moral disapproval, and then you have to go elsewhere. But generally speaking, in this country, you can't recover because of dignitary harm, because of the way that someone who spoke and their moral views made you feel. So instead, the goal is to treat husband and wife belief that required for marriage as opposition to interracial marriage.
I think with that, we're going to close the public questioning. It's too bad that y'all don't have strong opinions that you like to argue for. I feel like we could go on here until midnight. Thank you all for staying with us for this question and answer. And I think our speakers will take some other individual questions up front at the end of our thanking them. So let's have